Ms. Sylvia.
Mr. Speaker, sir, I declare my interest as a lawyer working in a firm that practices criminal law. Sir, as my Workers' Party colleagues have said before me, we are unable to support the bill this time. Sir, at each renewal of the Act, MPs are asked to consider whether the prevailing circumstances are such that we still need this law. On the one hand, we know that Singaporeans want Singapore to be a safe place to live in for ourselves and our families. At the same time, we are very mindful of the trade-offs of giving the government too much power to detain people without a fair trial, as power can always be abused. This is all the more so when we are dealing with powers to deprive people of their liberty for years. During the past renewals of this Act, the Workers' Party has accepted the uncomfortable compromise that this law entails on the constitutional right to freedom. We did not delight in taking this position, but did so with a heavy heart. This time, however, our view is the government has gone too far. How so? My colleagues, Mr. Pritam Singh and Dennis Tan, have already set out their concerns about the bill's apparent curtailment of judicial oversight. For my part, I will focus on 3 points. First, the timing of this renewal. Secondly, the dangers of adding the 4th schedule to the Act. And thirdly, add my voice to the disapproval of Clause 3, making the Minister's decision to detain final. First, the timing of this renewal. I agree totally with the Honourable Member Mr. Murali, and am very surprised that Parliament is being asked to extend the Act now, in February 2018, when the current Act only expires in October 2019, 20 months from now, towards the end of next year. Past debates for renewals of this Act did not have such a long timeline. The Honourable Member Mr. Murali produced a table. For my part, I did the counting from the second reading of the bill, not the first reading, which is in his chart. And from my counting, the last debate for renewal was in November 2013, less than a year before the expiry date in October 2014. The previous 2 renewals, in 2009 and 2004, were debated even closer to the expiry date, between 1 month and 8 months of the Act's expiry. Why is the timing of the renewal important? It is important because at each renewal, MPs are asked to consider the prevailing crime and order situation then, and to decide whether an extension of the Act is justified for another 5 years. The government itself has refrained from making the Act permanent, which means that at each renewal, MPs must satisfy themselves that the Act is needed for the next 5 years. Today, Parliament is asked to assess that the circumstances justify the renewal of the Act from October 2019 to October 2024. Notwithstanding what the Minister earlier shared with the House on the crime situation both here and regionally, how do we know what the situation will be like towards the end of next year? Things can always change. How will Parliament make a reasonable assessment of prevailing circumstances so far ahead of time? Does this not make a mockery of the careful consideration Parliament is to exercise when assessing whether prevailing circumstances justify a renewal of this draconian law? In my view, sir, it is premature of the MHA to come to Parliament now to ask for a renewal of the Act. Next, I move on to the inclusion of the new 4th schedule. Clause 8 introduces a new 4th schedule to include a list of offences which the Minister can detain a person for. In MHA's press release of 9 January, it is stated that the purpose of the new 4th schedule is to, and I quote, restrict the powers of the Minister by clarifying the scope of criminal activities under the Act, unquote. But as I read the bill, this is not true. The bill, in fact, increases the Minister's powers. Why do I say that the bill increases the minister's powers? Yes, the current Act does not list which kinds of criminal activities would make a person liable to be detained. But that does not mean that the minister currently has carte blanche to detain anyone he pleases. In the landmark decision of the Court of Appeal in Tan Seet Eng and Attorney General, referred to earlier, the Apex Court made it very clear that the minister's powers under the current Act are quite limited. In Dan Tan's case, the Court of Appeal did a thorough examination of the origins and purposes of the Act and also scrutinized parliamentary debates on past renewals of the Act. The Court then came to some important conclusions. First, the judges concluded that the CLTPA did not cover all offences, but only criminal activities where trials in court could not proceed due to threats of harm against witnesses or their families. Secondly, the detainee must have been involved in a criminal activity of a sufficiently serious nature to justify detention without trial. And thirdly, the criminal activity must pose harm to the public order within Singapore. In Dan Tan's case, the court found that the grounds of detention alleged that he was the mastermind of a global soccer match fixing syndicate, but the effect of his plans were felt in other countries and did not affect the public safety, peace, and good order within Singapore. Now, earlier in the minister's speeches and interventions, he appeared to be somewhat watering down the effect of the Dan Tan judgment. But if I may be permitted to make my own assessment of the significance of the judgment, the court there made it very clear that it had a duty to objectively assess whether the minister's statement of facts is coherent and within the legal scope of the Act giving him those powers. The court stated very clearly that its role was not limited to applying a subjective test as to whether the minister believes that he is making the correct detention order, but it was much more than that. The court had to look at the legal framework provided by the Act, what the Act is set out to achieve, the mischief it seeks to cure, and whether the case made out by the government on its face furthers that purpose. And because the court was not satisfied that the first detention order against Dan Tan furthered the purpose of the CLTPA, the court found that the Act could not apply to such a case and declared the first detention illegal, ordering him to be released. So, bearing in mind what the court has said, will this bill now restrict the minister's powers, as MHA says, or in fact expand them? Let us examine the effect of the inclusion of the new fourth schedule. The schedule will likely short-circuit the assessment process of cases suitable for detention. In other words, the inclusion of the schedule may enable the minister to bypass answering questions as to whether a case is serious enough to justify detention or why it is not possible to prosecute these persons in court. Concerns have already been publicly raised by several lawyers and academics that the bill potentially allows persons to be detained for alleged activities of a more minor nature now that there is a list of defined activities in the fourth schedule. So, another striking feature of the activities listed in the new schedule is item 9, participation in or facilitating any organized crime activity as defined in the Organized Crime Act 2015 or OCA. Now, what will this mean if the bill is passed? This will mean that the scope of the Act, CLTPA, will be expanded to cover activities that are done overseas or that may not pose a threat to the public order within Singapore. Earlier in the minister's second reading speech, I noted that he was very careful to say that the schedule consisted of crimes or activities that had been previously mentioned in the House, and it also brings in the OCA, which I take to mean that he recognizes that the inclusion of the OCA is something new, not discussed or contemplated by the previous discussions on the CLTPA. So, under Section 48 of our OCA, actions done abroad are considered to be organized crime activities so long as they are done by an organized group with local links. These activities could take place completely in countries far away. In addition, by referring to the OCA in the CLTPA schedule, the government is importing into the CLTPA the concept of serious crime under the OCA. But the OCA considers to be serious crime a wide variety of offences, including many crimes that are fundamentally economic or financial in nature. The list of such crimes includes GST fraud, dealing in goods for which customs duty is not paid, illegal betting, computer misuse, and infringements of copyright and trademarks. Do such types of cases typically come up for detention under the CLTPA? I do not think so. Sir, the OCA already has its own ways of dealing with organized crime, which MHA recommended and Parliament only recently adopted in 2015. By now linking the OCA to the CLTPA, enabling CL detention for OCA cases, is the new schedule not expanding the minister's powers under the CLTPA? Sir, the Court of Appeal in Dan Tan's case has pronounced that the CLTPA is only meant to protect the public safety, peace, and good order within Singapore. Contrary to what MHA has said, my view is that the inclusion of the fourth schedule under Clause 8 clearly expands the minister's powers to police criminal activities overseas and expands the kinds of activities that are subject to the Act. In effect, the bill makes the minister a global policeman with no equal in the world. This is a position too arrogant for the House to support. Sir, next I move on to Clause 3, which purports to make the minister's grounds of detention final. Sir, the attempt to make the minister all-powerful under Clause 8 is even more toxic when one looks at Clause 3, which states that every decision of the minister to exercise detention powers under Section 31 is final. Other MPs have raised their concerns about the clause. I will only add a few points to the chorus of concern. Sir, the court's powers in judicial review are already very limited. As my party colleagues and other MPs have said, the principles of judicial review are well established. When a court is asked to review a government decision, it will overturn the government's decision only if it finds that the decision was illegal, irrational, or procedurally improper. Our judges are well aware that they are not ministers and should not be the ones exercising executive discretion. Earlier in his speech, I believe the minister clearly understands these principles. So, sir, what is the justification for the government to introduce Clause 3? The minister keeps saying and saying that it's not intended to change the legal position, it's meant to preserve judicial review, but it is a tenet of interpretation that Parliament does not legislate in vain. Now, earlier, if I heard the member, Mr. Christopher D'Souza, correctly, he attempted to suggest that Clause 3 was merely meant to clarify the current position. But if one looks at the explanatory statement to the bill, it does not say it as such. The explanatory statement to the bill says that this bill seeks to amend the CLTPA for the following purposes, and the first purpose is to provide that the minister's decision will be final on these points. So, this is very troubling. If what the minister is saying is correct, that is, Clause 3 is not meant to change anything, then why introduce it at all? Why not leave it as a status quo instead of causing confusion and possible problems down the road about what this clause is meant to cover? So it is quite clear that the government is not infallible and does make mistakes. Dan Tan's detention illustrates this. Instead of welcoming the court's clarification, the government comes to Parliament with this finality clause. As MPs, it's important for us to pause and ask, what is the public interest here? Why is Clause 3 necessary? Does the public interest not demand that we defend rigorously the court's constitutional duty to ensure that the government acts lawfully? Sir, the CLTPA has been in force since 1955, and for more than 60 years, no minister has come forward to ask for a finality clause on his detention orders. We find this very troubling. Sir, let me summarize. As I mentioned earlier, I have my reservations about the timing of this bill, as I believe that to renew the Act now to take effect in October next year is premature. More importantly, the Workers' Party does not see any justification to introduce a finality clause as proposed in Clause 3. In addition, I find that the insertion of the fourth schedule under Clause 8 is dangerous, as it clearly expands the minister's powers rather than restricts them, as claimed by MHA. The bill will expand the scope of the CLTPA beyond its original intention of safeguarding peace and good order in Singapore. These clauses will repose in the Minister for Home Affairs too much discretion and power, not only at home, but well beyond our shores. We find this proposal untenable. For these reasons, the Workers' Party opposes the bill.